Mr. Ashok Parija, Learned Advocate General, Mr. Jagabandhu Sahu, Learned President, and other office bearers of the Odisha High Court Bar Association, Mr. P.K. Padi, Learned Assistant Solicitor General, Government of India, learned senior advocates and members of the legal fraternity, members of the registry, ladies and gentlemen. It is with grief and anguish that we have assembled today to condole the sad demise of Honorable Mr. Justice S. Ranganathan, one of the erudite and finest of the former judges of the Supreme Court of India, who breathed his last at 12:30 a.m. in Chennai on 20th January 2022 at the age of 94. Recently, another erudite judge of the Supreme Court of India, Justice R.F. Nariman, on the eve of his retirement in August 2021, released a 2-volume treatise titled Discordant Notes, The Voice of Dissent in the Court of the Last Resort. I will have occasion to refer to this book again later. However, what provides the perfect backdrop to the person we are here to remember is a quotation in the said treatise from a book by Professor Alan Hutchinson titled Laughing at the Gods, Great Judges, and How They Made the Common Law. Professor Hutchinson, speaking of great judges, has this to say. I quote, "Great judges seek to make a critical accommodation with the legal tradition by combining heresy and heritage in a playful judicial style. They refuse to be hampered by customary habits of judicial mind. For them, law is not something to be mastered. It is a sprawling tableau of transformation in which experimentation and improvisation are valued as much as predictability and faithfulness to existing rules and ideas. They see possibilities and make moves that others overlook. Great judges flaunt conventional standards in the process of remaking them. Their judgments are the exceptions that provide the rule. And once they have done what they do, others are less able to view the world in the same way again." Justice Ranganathan was certainly a great judge in the above tradition. He was born on 31st October 1927 and hailed from a learned family in Tanjavur district in Madras. He was the youngest of the 4 sons of Sri R. Srinivasachari, who was a renowned engineer of the Public Works Department, Chennai, and Srimati Kodayamma. From his childhood, he proved to be a brilliant student. He had his schooling at Pendatur Subramaniam High School, Mylapore, Chennai, now known as PS High School, and was the recipient of the Sundari Ammal Gold Medal in the SSLC class. He continued his collegiate studies at the Presidency College, Chennai, where he was awarded the Junior Thompson Prize for proficiency in English and continued his studies to obtain his BA Honours degree in mathematics in 1947. Thereafter, he pursued studies in law at the Madras Law College and obtained his BL degree in 1949 and was the recipient of the Lakshmi Narasa Reddy Gold Medal. After completing his BL, he joined as a law apprentice with Sri C.S. Ramarao, a renowned standing counsel of the Income Tax Department at Chennai. He completed the apprenticeship in 1950. Thereafter, Justice Ranganathan enrolled as an advocate of the Madras High Court in July 1952 and continued to work as a junior lawyer with Sri Ramarao. He was very passionate in higher studies and continued pursuing that passion by securing an ML degree in 1953 while still in practice. On 1st October 1954, Sri Ranganathan was appointed junior standing counsel to the Income Tax Department. Within a short span of 7 years, he became the standing counsel for the department. Justice Ranganathan's senior, Sri Ramarao, was known to be an extremely fair counsel. Justice Ranganathan imbibed those values and continued the same tradition, earning the respect of both the bar and the bench. It was a loss to the bar and a gain to the Income Tax Appellate Tribunal, the ITAT, when he joined it as a judicial member in 1964 with his first tenure in Calcutta. He rose through the ranks of the ITAT, becoming the vice president of both the southern and northern zones, and later the president of the ITAT in 1976. It was apparent from his erudite opinions delivered in the ITAT that Justice Ranganathan's learning and experience was meant for higher responsibilities. Fortunately, this merited recognition when he was invited to the bench of the Delhi High Court in the year 1977. I have heard from several of my colleagues of the Delhi High Court, where I too was fortunate to be on the bench for over 14 years, and from many of the senior practitioners there, that Justice Ranganathan soon became a favorite of the Delhi bar with his remarkable patience and pleasant demeanor, which he displayed while on the bench. His expertise was not confined just to tax matters. He sat on almost every roster of the Delhi High Court, including the criminal roster. In fact, he presided over the bench that heard the appeals of the convicts in the Srimati Indira Gandhi assassination case. It was a proud moment for the bar in general and the tax practitioners in particular when Justice Ranganathan was elevated as a judge of the Supreme Court of India in 1987. This was perhaps the first instance that a member of the ITAT reached the topmost court in the country. Justice Fatima Bibi, as many of you would be probably aware, was the second member of the ITAT who then went on to the High Court in Kerala and then became a judge of the Supreme Court, the first woman judge of the Supreme Court of India. As a young advocate who had only recently joined the Supreme Court bar, I was extremely fortunate to watch the proceedings of the bench of Justice Sabyasachi Mukherjee and Justice Ranganathan, which by itself was a learning experience. The manner in which these two learned judges conducted the proceedings elevated the debate of the bar, even in ordinary cases, and was a treat to watch. The esteem in which Justice Ranganathan was held by his colleagues in the Supreme Court was evident when he was asked to be part of the Constitution bench of 7 judges that delivered the landmark judgment in A.R. Antule versus R.S. Nayak, AIR 1988 SC 1531. In fact, both Justice Venkatachalaya, the Chief Justice of India, as he was to later become, and Justice Ranganathan, was sworn in the Supreme Court on the same day, 5th October 1987. And within a few months, both these eminent judges were already part of the Constitution bench of the Supreme Court. And what is remarkable in the Antule case is that, being the younger, junior-most members of that 7-judge bench, they wrote powerful dissents in the Antule case, which has become a landmark for all law students and all lovers of the law. While the dissenting opinion of Justice Venkatachalaya, as the learned Chief Justice of India then was much discussed, the separate dissenting opinion of Justice Ranganathan, who concurred with Justice Venkatachalaya on some of the important aspects regarding error in jurisdiction and error of jurisdiction, developing on the principles laid down in the anismenic case of the House of Lords, is a must-read for every ardent student of the law. Basically, Justice Ranganathan held his own among all other stalwart judges of the bench. In fact, in his dissent, Justice Ranganathan differed from Justice Venkatachalaya, with whom he concurred. In fact, they were the two dissenting opinions on the bench on a very important aspect of whether at all the Supreme Court could revisit its order other than in a review jurisdiction. And this is what Justice Ranganathan had to say. And I assume that Justice Ranganathan had great foresight because he anticipated what might happen a decade later in the Supreme Court in the Rupa Hora case. And I, with your permission, quote from Justice Ranganathan's dissent in the Antule case. The Appellant's Counsel, I'm quoting, the Appellant's Counsel has relied to a considerable extent on the maxim actus curiae neminem gravavit for contending that it is not only within the power but the duty as well of this court to correct its own mistakes in order to see that no party is prejudiced by a mistake of the court. I am not persuaded that the earlier decision could be reviewed on the application of the said maxim. I share the view of my learned brother Venkatachalaya J that this maxim has very limited application and that it cannot be availed of to correct or review specific conclusions arrived at in a judicial decision. My brother Justice Venkatachalaya has further taken the view that this court cannot exercise any inherent powers for setting right any injustice that may have been caused as a result of an earlier order of the court. While alive to the consideration that the highest court in the land should not, by technicalities of procedure, forge fetters on its own feet and disable itself in cases of serious miscarriages of justice, he has, that is, Justice Venkatacharya has, nevertheless come to the conclusion that the remedy of the appellant, if any, is by recourse to Article 137, that is the review power, and nowhere else. It is at this point that I would record a dissent from his opinion. In my view, the decisions cited do indicate that situations can and do arise where this court may be constrained to recall or modify an order which has been passed by it earlier, and that when ex facie there is something radically wrong with that earlier order, this court may have to exercise its plenary and inherent powers to recall the earlier order without considering itself bound by the nice technicalities of the procedure for getting this done. As some of us would recall, in Rupa Rao versus Ashok Hurra, when the Supreme Court created, more than a decade later, the curative jurisdiction, this is what formed the basis for that exercise of curative jurisdiction. Justice Ranganathan was a fearless judge, independent and completely impartial and dispassionate. Before him, the status or experience of the counsel mattered least, and the weight of the arguments alone mattered. For students of the law who are interested in clarity and exposition of the basic principles of law, the opinion of Justice Ranganathan in Reliance Petrochemicals versus Proprietors of Indian Express, AIR 1989, Supreme Court 190, is worth reading. And at this stage, I would go back to Justice Nariman's book, Discordant Notes, where while quoting Justice William Douglas, he explains what is the value of a dissent. It must be recalled here that apart from the dissent in A.R. Ampule's case, Justice Ranganathan gave two more powerful dissents, one in the Charanlal Sahu case, and that too has been noted by Justice Nariman in his book. Justice William Douglas of the Supreme Court of the United States says this: when we move to constitutional questions, uncertainty necessarily increases. A judge who is asked to construe or interpret the Constitution often rejects the gloss which his predecessors have put on it. For the gloss may, in his view, offend the spirit of the Constitution or do violence to it. That has been the experience of this generation and of all those that have preceded. It will likewise be the experience of those which follow, or so it should be. For it is the Constitution which we have sworn to defend, not some predecessor's interpretation of it. Stare decisis has small place in constitutional law. The Constitution was written for all time and all ages. It would lose its great character and become feeble if it were allowed to become encrusted with narrow, legalistic notions that dominated the thinking of one generation. And therefore, you find that Justice Ranganathan, even when he was part of a concurring majority, never hesitated to pen a few words of concurrence and brought to the debate something rich. And this is what is remarkable about Justice Ranganathan. Again, for students of the law who may be interested in knowing the niceties of the concept of reference by incorporation, that is, you refer to a legislation in another legislation and what that entails, I would urge you to read Justice Ranganathan's concurring opinion in Ujagar Prints versus Union of India, 1989, 3 SEC. I could go on and on of Justice Ranganathan's erudite opinions, but I know the time is short. Justice Ranganathan was a recipient of the National Citizens Award 1992 for his contribution to law and jurisprudence, presented to him in 1994 by the then Vice President of India, Shri K.R. Narayanan, at New Delhi. After his retirement from the Supreme Court, Justice Ranganathan served for 2 years as member of the 13th Law Commission of India. He was then appointed as the chairperson of the Authority for Advanced Rulings, a quasi-judicial body created under the Income Tax Act 1961, and held that post till his retirement on 30th October 1997. After retirement from service, Justice Ranganathan continued staying on in Delhi, engaging himself with consultancy and arbitration work for a few years. Thereafter, he returned to Chennai to spend his retired life at his residence in Chennai. Early in his career, Justice Ranganathan was associated with the revision of V.S. Sundaram's income tax in its 7th edition. He later revised A.C. Sampath Iyengar's Law of Income Tax for its 7th and 8th editions. Justice R.V. Ishwar, a former judge of the Delhi High Court, tells me that what was a 2-volume compilation of A.C. Sampath Iyengar on income tax law with Justice Ranganathan's revision became a 9-volume compilation. Justice Ranganathan also authored a book on corporate taxation in India. He delivered the Sir Alladi Krishnaswamy Iyer Memorial Lecture on the Constitution of India 5 decades, reviewing the amendments made in the Constitution between 1950 and 1999, which was brought out as a book in 1999. Apart from the legal discipline, Justice Ranganathan's interests included a lot of reading. He was an erudite Sanskrit scholar. In 1999, under the auspices of the Bharati Vidya Bhavan, a book on Meghadutam and Hamsa Sandesha, a parallel study, a comparative translation in English of the works of the 2 great Sanskrit poets, was published. He reverted to his reading and writings after retirement, and in 2017 came up with a book on Sundarakandam of Srimad Valmiki Ramayana, released at the Tax Center at Chennai. Justice Ranganathan leaves behind his wife Srimati Hemalata and his twin daughters Rupakala and Deepmala, both of whom are qualified lawyers and company secretaries. The demise of Justice Ranganathan is a great loss, not only to his family and friends, but to the Indian judiciary as a whole. His ideals will be an inspiration for all of us. On behalf of my sister and brother judges, and on my own behalf, I express our heartfelt condolences to the members of the bereaved family and pray that the departed noble soul of Justice Ranganathan rests in peace. We also pray for strength and courage to the members of his family to bear the irreparable loss.
My Lord, Honorable the Chief Justice, my Lord's companion judges, members of the registry, the Assistant Solicitor General of India, Sri Prasanna Kumar Padi, the President, High Court Bar Association, Sri Jagabandhu Sahu, Vice President, Secretary, and other office bearers of the association, respected senior members of the bar, and my junior colleagues. On behalf of the state and my colleagues, I convey our deepest condolence on the sad demise of venerated former Judge of the Supreme Court, Honorable Justice S. Ranganathan, who has left for his heavenly abode at the age of 94. Late Justice Ranganathan was born in Chennai. He did his high schooling in PS High School, Chennai. Thereafter, he pursued his higher education in the prestigious Presidency College. A keen student, he thereafter studied law and enrolled himself as an advocate. Justice Ranganathan commenced his practice as an advocate in the Madras High Court in 1952. Within a short span of time, he was appointed as Standing Counsel of the Income Tax Department in 1954, a testament to his prowess as a leading practitioner. A noted tax scholar, he joined the Income Tax Appellate Tribunal as its judicial member in 1964 and was subsequently elevated as president of the ITAT in 1974. Thereafter, after 3 years as president of ITAT, he was elevated as a judge of the Delhi High Court, wherein he adjudicated eruditely on all branches of law. He was known to be very soft-spoken, humble, and patient in dealing with the bar. On 5th October 1987, late Justice Ranganathan was elevated to the Supreme Court of India, where he authored jurisprudentially trend-setting judgments on tax law. He was a part of the multiple constitution bench, authoring landmark judgments, including A.R. Antole and Charanlal Sahu. He retired from the Honorable Supreme Court on 30th October 1992. Post-retirement, late Justice Ranganathan continued to be associated with tax law, becoming the first chairman of the Advanced Authority of Ruling. He was appointed as chairman of the Law Commission of India post his tenure as the AR. Toward the end of his life, late Justice Ranganathan retreated to more scholarly pursuits in Sanskrit. He even authored a book on Sundarakanda of Srimad Valmiki Ramayana. With his passing, India has lost a great servant. The legal fraternity has lost a great scholar and a gentleman, and his friends and family have lost a great soul. With these words, my lords, I would like to convey to the members of his family the esteem in which we held him during his life and the esteem in which we'll hold him after his death. May his soul rest in peace.
My Lord Honorable Chief Justice Dr. S. Muralidhar and Honorable Justice Judges of our High Court, Sri Ashok Kumar Parija, Learned Advocate General, Mr. Prasanna Kumar Padhi, Learned Assistant Solicitor General of Odisha, India for Odisha, Mr. J.K. Lenka, Secretary of our Bar Association, and other office bearers of our Bar Association, respected officers of the registry, esteemed senior members of our bar, and my other colleagues of the bar, and esteemed participants of today's condolence meeting. Born in 1927, Justice Ranganathan had pursued his education at PS High School, followed by higher education at Presidency College and the Government Law College in Chennai, and enrolled as an advocate of Madras High Court in 1952. Later in 1954, he was appointed as the standing counsel for the Income Tax Department, along with C.S. Kamarao Sahib, which assignment he had held with great distinction and presented the cases of the Income Tax Department fairly and objectively. He was appointed as judicial member of the Income Tax Appellate Tribunal in 1964 and had his first posting at Calcutta, which at that point of time was the premier center for interesting taxation disputes. He served the tribunal with great distinction and exhibited remarkable erudition and learning in his orders. He was elevated to the post of the president of the tribunal in 1974, and after 3 years as president, he was elevated as a judge of Delhi High Court in 1977. Justice Ranganathan's tenure for about 11 years in Delhi High Court saw him render several erudite judgments on all branches of law, including criminal law. In the year 1987, he was elevated to the Supreme Court of India, where he served till 1992. After retirement, the Government of India appointed him as the first chairman of the Authority for Advance Ruling. Under his able leadership, the authority was able to fulfill the expectation of the taxpayers and the Income Tax Department admirably. He also revised a treatise on income tax authored by A.C. Sampath Iyengar. The qualities Justice Ranganathan exhibited as a judge were a model for judges and members of quasi-judicial tribunals. His orders were elaborate but not unnecessarily so. Not a word or thought was wasted, and he wrote was only that what was opposite or pertinent to the dispute. The structuring of the judgments was so meticulously built, brick by brick, with one concept seamlessly merging into the other and logically flowing from the other. It was a pleasure to read them. He really went deep into the issue and would invariably trace the legislative history of the statutory provisions, which had to be dealt with, and set them out with a clarity and precision that was not easily attainable. His orders were considered excellent. He was one of those rare judges who was willing to change his own judgment. In a judgment, he said, consistency for the mere sake of it is no virtue. Towards the end of his life as a Sanskrit scholar, he wrote a book on Sundar Khandam and Mahalingam Record. Mr. Rangachari, former chairman of Insurance Regulatory and Development Authority, said he was a very soft-spoken man, highly principled, and very humble. He has said, my Guru Rangaswamy, along with Justice Ranganathan, were great friends. I have seen them together and been blessed by them. He was a very noble soul. Senior advocate Arvind Dattar said that Justice Ranganathan was an outstanding judge and delivered landmark rulings in several tax and constitutional cases. He became a member of the tribunal at a very young age. As a judge of Delhi High Court, he gave important and balanced judgments in A.R. Antule case, and he gave a criticizing dissenting judgment. One bizarre event I would recall at this point of time in Delhi High Court had never seen anything like it. Policemen armed with stun guns swarming over the premises and guarding every entrance and exit, two metal detectors at the only open entrance to the building, body searches of all entering the court, a metal detector outside the courtroom, a bulletproof screen across the judge's bench, and all for a brief 3 minutes on the occasion of delivering judgment in the Indira Gandhi assassination case. Precisely at 10:30 a.m. on December, Justice S. Ranganathan, B.L. Kripal, and Justice M.K. Chawla walked into court number 6 to pronounce judgment on the appeal in the Indira Gandhi murder case. Even as lawyers and onlookers continued to jostle outside the door to the small court, which can barely seat 30 people, a hush descended inside as the door was shut, and Justice Ranganathan, the senior most judge in the full bench, read out one script sentence, we see no reason to reduce or modify the sentence imposed on the accused by Mr. Mahesh Chandra. At 10:33 a.m., the judges exited. Former judge of the Supreme Court of India, Justice S. Ranganathan, breathed his last on Wednesday night on January 19, 2022 at Chennai after a brief illness. He was 94 years old then. He is survived by his wife and daughters. While joining in the mourning and sharing the grief of the members of the bereaved family of late Justice Ranganathan, I, on behalf of the High Court Bar Association, pray the Almighty to give enough strength to the grief-stricken members of the bereaved family to bear the loss. I pray God for the departed soul to remain in heavenly abode. With these words, I conclude my message of condolence.
As a mark of respect to the departed soul, let us observe 2 minutes silence. The court work will remain suspended for the rest of the day.